Helen Grus, an Ottawa detective with a stellar record, dared to dig into suspicious infant deaths potentially tied to the COVID-19 vaccine rollout, only to be slammed with a discreditable conduct charge for assessing records the brass called unauthorized. Her explosive 2-year hearing exposed a chaotic circus of bickering lawyers and a rigged system, with the hearing officer dodging the real scandal. Pfizer's own data showed a 97% infant fatality rate in trials, which Grus fought to expose, but the elite shut her down, proving the untouchable rule. But if truth and justice prevail, this proceeding is far from over. Helen Grus was a Ottawa police detective in the sexual assault and child abuse, that's the SACA unit, when she came under fire for various alleged infractions, the last of which stuck and was a discreditable conduct charge for improperly assessing the police records management system called RMS in what is being coined an unauthorized investigation into medical records of parents and babies who died suddenly and in unusual ways following the rollout of the novel modified RNA COVID-19 vaccines in 2021. Grus was a dedicated detective with a previous exemplary record, and supporters maintain that her access of RMS was essential to her duties as a diligent investigator, especially as it was determined that some of the investigative parameters involved in these sensitive cases were incomplete or lacking. The hearing into Detective Helen Grus's alleged discreditable conduct spiraled into a record 23.5-day procedure. Hearing officer and retired superintendent Chris Renwick describes counsel bickers, insults, and objections in his just-released decision, which he says led to struggles to rein in the mess that I say Ottawa police created. Renwick states in his decision that a large portion of the documentary evidence and oral testimony presented fell outside of the scope of the facts on the allegation of discreditable conduct. He claims that there were several days spent hearing irrelevant evidence and submissions on points that were clearly outside the scope of this misconduct hearing, and that as the trier of fact, it is incumbent upon him to remain impartial and to refrain from analyzing what is irrelevant to the assessment of the nature of the conduct in question. He furthered that it would be an error on his part to attempt to list and address all the submissions and evidence that he finds to be outside the scope of this hearing, and instead will confine his analysis to what is contained in the notice of hearing, noting that this may sound somewhat avoiding or simplistic, but he found himself compelled not to cloud an analysis and decisions with overarching themes that may have been woven into this hearing and are, frankly, not relevant to the essence of the alleged misconduct. This, I would say, fundamentally ignores the court-ordered release of Pfizer's own trial data that showed only one normal outcome out of 32 pregnancies, representing a nearly 97% infant fatality rate in unborn babies in their clinical trial data. By December of 2021, it was clear through independent review that Pfizer misrepresented their data to hide certain adverse outcomes, which isn't new behavior from the pharmaceutical oligarch who bought and paid for their Most Ethical Companies award for 4 years running, despite a clear track record of fraud and misconduct, including being a convicted felon in what was the largest healthcare fraud settlement at the time, $2.3 billion for false marketing with intent to defraud or mislead in the United States. They used misleading demographics, did not track any biomarkers, and even unblinded the participants a mere 2 months into the trial. That's just scratching the surface. Because not only that, but the novel modified RNA COVID-19 vaccines weren't properly tested on pregnant and breastfeeding women when the injections were being mass rolled out to the public. And the one normal outcome out of 32 known pregnancies only represents the minuscule amount that made it into these clinical trials. Even though this clearly showed a significant risk to pregnant women and their infants in the clinical trial data, Renwick states that it is outside his scope to address the accusations by the defense on their perceived political motivation of the PSA, that's the Police Services Act charge, nor the defense's allegations of police misconduct and or criminal accusations against various members of the Ottawa Police Service, including SACA colleagues, supervisors, the Professional Standards Unit investigators, senior officers, and prosecutors. In doing so, Renwick would be far exceeding his authority as a hearing officer into this specific instance of one count of discreditable conduct. This extends to the defense-raised issue of alleged internal Ottawa Police Service media leaks and whether they were adequately investigated or addressed. Renwick further concludes that any aspects of the actions of Canadian public health leadership on the approvals and implementation of vaccinations and weighing into any analysis or position on the science pertaining to vaccinations is out of the scope of relevance of the tribunal. In his analysis, Renwick specifies that Grus did try to bring her concerns with the unprecedented response to COVID-19 and subsequent vaccine rollout coinciding with mandates up her chain of command. Quote, she sent unsolicited COVID-19 emails and research material to HSL, the pandemic team, the Professional Development Center, the OPA, the executive, and ultimately posted to all OPS members, unquote. But this was ultimately chalked up to a personal interest, and Grus's due diligence to ensure medical questionnaires were being adequately completed and recorded in her unit was described as a self-initiated, unauthorized project that was ultimately viewed as her interfering in an investigation. Renwick ultimately ruled that a reasonable person would understand the community's collective response of concern should they have learned that such unauthorized criminal negligence inquiries on public officials were being undertaken by a criminal investigator within SACA. The public would expect their police service to exercise proper and effective oversight and authority over their employees to ensure a bias-free approach when conducting criminal investigations. Now, this report, as presented by Renwick, comes across as a deliberate attempt to narrow the scope while sidestepping the broader, inconvenient at best, implications of Detective Grus's actions. It's methodical, almost surgically so. It's confining itself to the notice of hearing, dismissing swaths of evidence and testimony as irrelevant. The tone feels detached, even defensive, as Renwick justifies his restraint by emphasizing impartiality and judicial limits, which could read as either principled or evasive, depending on your perspective. His frustration with the hearing's chaos, counsel clashes, public disruptions, and endless objections bleeds through, painting a picture of a process teetering on collapse, yet he doubles down on relevance like it's a lifeline. The refusal to engage with the defense's wider claims from political motives, vaccine risks, or Ottawa Police's own internal misconduct seems like a missed opportunity to wrestle with the case's real stakes, especially given the gravity of infant deaths and public trust. It's a report that prioritizes containment over confrontation, leaving an aftertaste of unresolved tension. Whether that's a strength or a flaw hinges on what you think the hearing should have been about, a tight disciplinary review or a reckoning of systemic rot. And published just days ago as a peer-reviewed paper indexing the very discrimination against individuals who opposed COVID-19 vaccine mandates, the same ones that Grus faced, validating the issue and quantifying its extent. The authors call for formal public, political and judicial investigations into state-level discrimination and advocate for broadening human rights protections to include a wider range of beliefs, opinions, and lifestyles, emphasizing the need for public health to respect individual autonomy and voluntary participation. Grus's lawyer Bathsheba Vandenberg says Renwick's decision undermines the provisions of police services to protect our communities and sends a strong message to Canadians that public officials are above the law. Stay tuned because this story isn't over yet. For Rebel News, I'm Tamara Ugolini. If you'd like to follow the facts and find some evidence-based reports, please do so at nomoreshots.ca. At that website, you can send a form email to former Minister of Health Mark Holland calling on him to revoke market authorization for these injections and sign our petition if you agree. That's nomoreshots.ca.